Je vous dis bonjour.
So, good afternoon. I'd like to thank you very much for having invited me and for giving me the possibility to once again preach to you and to be able to share my passion with you within the framework of this conference. I'd also like to thank you for the invitation, and I find that your hospitality has been absolutely magnificent. I'm very briefly going to introduce myself. As was said, I'm the coordinator of the Legal and Court Interpreting Committee, and I represent AIIC within the European Association of Interpreters and Translators, which was founded within the framework of a European project in which AIIC participated, and of which AIIC is an associate member and makes legal interpreting at European level progress. And I work as an interpreter in national and international courts. I also teach. This makes it possible for me to mention certain aspects concerning training, and I've participated in numerous European projects which have managed to make progress in achieving more justice within European courts. As you can see, I'm busy on all fronts. My commission or committee has helped me very much in this regard, and just to explain why I considered that it's a real passion for me, I'll just tell you about my anecdotal experience. I was a young interpreter, and I was at the European Commission, and for a whole day we interpreted, 6 interpreters, 3 booths, in an agricultural committee where people were discussing different issues. Now, for the whole day we had interpreted the importance of the lavage des eaux, and afterwards I'll explain to you why it's important if you didn't know why. And people got very excited. We carried out honest work. It was correct. And we weren't geniuses, we were just simply professionals. And the next day, as I am a sworn interpreter for the tribunal in Hamburg, I was at a hearing, and within the framework of this hearing there was an interpreter for Spanish, there was one for French, who was myself, and there was another one for Chinese. And not being very far from the interpreter for Chinese, I said, well, I understood that that person was getting angry with the client in German, so speaking angrily to the client in German. Well, this is an interpreter for Chinese, why is he doing that? And I got close to that person when there was a small break. Why are you speaking in German? And he said, because I'm an interpreter, I'm a Mandarin interpreter, not Cantonese, so what are you doing there? And he said, my dear colleague, more I stay, or more money I get. So I say, well, I'm not going to denounce you for that, but I think you have to disappear quickly. And that was a shock, a decisive shock as far as I was concerned. It made me see the contrast that there was interested in that. It's very important. It's important for all types of industries, but the sentence in this regard was for 6 years. So in a similar case, I think that there's just no comparison here. You've got human lives which are undertaken here, and you have economic interests which are justified, which are honorable, but when it coincides with such contrast, and when you have a tribunal where you have to ensure that law is respected, and you need to have a fair trial where you also have to benefit or enjoy the respect of our rights and enjoy dignity, all of this is not the case. And this awareness raising made it possible for me to see that I had to do something, because on the one hand you've got interpreters who are qualified, but what's the point if you accept just anything? So now, my awareness-raising conscience, where it concerned people who had been arrested at the criminal level, what I saw a short time afterwards as I progressed within this profession was that not only were there persons for whom we didn't correct correctly, who didn't enjoy their rights, but there were also victims or children who were perpetrators and victims at the same time. They were traumatized. And if we allowed for these children to be confronted with interpreters who were not qualified, who didn't speak the language correctly, or were brutal to their own children, then in what life, in what place are we? How can an interpreter who is worthy of a name deal with that situation? So now the first measures that were taken, there was this awareness raising that was undertaken. Now the first that took place, firstly, what we said was that you had a situation where the allophones had to be treated in the same way as a person who does not speak the language of the tribunal. There was no reason why somebody who is confronted with a court or dealing with the police has not the same rights. Now, this awareness raising that took place went back a long way. So, where it concerns the interpretation in courts, well, that goes back to 78, if I'm not mistaken. And from this law, it was decided that the administration was responsible. That's not the case in Europe, but the administration was responsible for the selection of interpreters, and if we could not find a certified interpreter for the language concerned, in such a case, that had to be justified, and there could be recourse to a non-certified interpreter. So we are not there in Europe yet, where unfortunately in a lot of countries an interpreter just has to go to the registry, write a postcard or whatever. That person will be recruited easily. And in the US there was a register that was set up, and what's recommended now is that the European Union has one as well. You have a lot of states which offer training, and that has been done, well, that was done before the year 2000. Now, when we see the performance of interpreters during the O.J. Simpson trial, which was televised, I think that you can see that the quality of the service was quite stupefying. And really, when you doubt the possibilities that have to be offered within the framework of legal interpreting, that's something we really need to take into account. Now, within the EU framework, that doesn't go back very far. There are directives which have been issued. They're extremely important. They were launched in order to improve the quality of the interpretation. One directive for interpretation and translation in criminal proceedings, and another which is based on the first directive and which establishes minimum standards on the rights, support and protection of victims of crime and all vulnerable persons. Now, the main points of these directives, and it's completely new. If you think that the first goes back to 2010, it's firstly about the quality of interpretation. So an interpreter who doesn't interpret correctly, or a translator who also doesn't translate correctly, some articles also deal with translation, that person can be recused that was certainly not the case before, when there were abuses in terms of bad interpretation that led to the court in Strasbourg acting, and there was a lot of jurisprudence in this regard. And while the Strasbourg judges themselves had the assistance of qualified interpreters, they found, according to the jurisprudence, which they considered normal, the fact that the interpretation could be approximative. There was a decision concerning a Turkish interpreter who had insulted the suspect, and that person had really given his impression given the Kurdish suspect, and after 6 years that led to the ECHR acting, given that the person saying that the fact that he had expressed his opinion wasn't so bad. And there are other examples of that. So following the directives, or after these directives, we insist on quality. There are elements concerning ethics, in particular concerning professional secrecy and confidentiality, which was not the case before. Furthermore, the directive proposes that the users in the judicial world have training in working with interpreters, and certain member states have taken that very seriously in order to start organizing seminars with the help of interpreters or trainers, drawing attention to cultural problems, fatigue, and others. And they continue to propose such training. Now, the directive also proposes the creation of registers. I said that exists in the United States and has done for a long time, but it hasn't yet been fully carried out. Now, I also mentioned the term legal. Now, why that? Within the EU, they say legal and not judicial, given that interpreters working in the legal field do that not only in a courtroom. They work for notaries, they sometimes work for the police, they sometimes even work in arbitration. And so we wanted to cover that, and that's why the EU adopted that terminology. Now things also have advanced. There is a standard in preparation, and 2 members of our committee are also involved in that ISO committee to define and set out conditions of legal and court interpreting. And within the FIT Congress, there's a round table which deals with that. Now, in terms of this awareness among current states, after many years, it has been recognized that training is necessary, given the complexity of the tasks which need to be carried out. It is necessary for interpreters not only to carry out liaison interpreting, but also to master all interpretation techniques: consecutive, sight translation, simultaneous interpretation, and also they also introduce video conferencing now, and in certain member states it is not only consecutive. In certain other member states they had only used consecutive in video conference because the interpreters at local level are not qualified, and because the judges did not have explanations with regards to the possibility of what could be done in a video conference. Now, there is no contact between the national judges, and at international level there's a major separation. We can show them what's being done, and we can try and get the message to go across. Now, what's also massive by way of importance is the ethical training at all levels. In terms of legal interpreting, ethics is of fundamental importance, but not ethics which is just limited to working conditions or pay. That's also important, but it's not just part of ethics, but also from a point of view of the respect of rights. So integration of ethics into the rights of persons, fundamental rights. That's the difference that I would see in teaching ethics, which should always have an aspect linked to human rights. The person subject to judicial proceedings has to be in the same position as others who speak the language of that country. They all have to have the same conditions applying to them. They should have access to the language. So in France, Germany, the UK, if there's a national who speaks the language, somebody who has modest intellectual capabilities, they will have great difficulties in understanding what is known as legalese. That person will have great difficulty. Just as others may do, and that's the reason why it's not up to the interpreter to modify the register of the language. It's up to the judges from an ethical point of view. If he's not understood, to change language, but the interpreters are not meant to be the filter there. Furthermore, the interpreter also has to acquire substantial legal information and background in the training. So in the training that I organize continuous professional development in Magdeburg, and 50% are taking judicial proceedings for the first time as a subject. And they also have to be able to deal with difficult psychological situations, for example, when you have to interpret for a vulnerable person. So as you can see, in order to carry out a correct work, to be able to respect the rights of persons, people subject to the law and victims, you have to undergo training. If there is no training, there are abuses. And there is no reason why we should tolerate that. So all this has to be learned. And what causes the greatest problem, and was mentioned in the introduction to the conference, what is causing the greatest problem in order to obtain this training, those are the languages of lesser diffusion. Before I go into an explanation, I don't want to extend that to too much, but what are we speaking about when we speak about languages of lesser diffusion? Now, the definition is to say that a language that has no international diffusion, so Chinese and Arabic, for example, these are languages of lesser diffusion in Hamburg, for example. So it does depend on the geographical area you're talking about. Now, where there is not much training for interpreters, what can be offered? If you think about Tagalog, Twi, Sangara, etc., such languages, for those languages, even if those are languages which have significant diffusion in a particular geographical area, these languages nevertheless are of lesser diffusion in other regions. And by way of consequence, you have no university training in those languages. So you can't go with a traditional master's, you have to adapt. Furthermore, you have very few qualified interpreters. So if you have very few qualified interpreters, there will be few potential trainers. So how can you therefore guarantee a fair trial with languages of lesser diffusion? There are solutions to that. Now, in training, the solution that you have in the United States and within the European Union, you have training which is quite rigorous, which is proposed. You have tests that are carried out. You have certification. And after the adoption of directives within the European Union, we saw that a Pandora's box had been opened because we didn't quite know how we were going to be able to resolve the problem. And the method of DG Justice was to launch a call for a project, and I showed you a whole list of different projects, and academics, professionals, AIIC participated in a traffic project, for example. They try jointly to come together within a consortium and try to put together projects in order to provide solutions to these different problems. Now I'm going up to what I would call social interpreting. I don't know how many names there are. Public service interpreting, community interpreting, and all these different categories and names exist. But depending on different countries, you have variable definitions of what this is. And as such, there is a massive difficulty in being able to set out exactly what it is. What's the limits of it compared to legal interpreting, for example? In my opinion, and in the opinion of my commission, legal interpreting is different to community interpreting or social interpreting, because you have the legal aspect and the importance of training in that area. So the situation is very clear. What's also very interesting is to say that with this idea of community interpreting, which has developed, this is a political term which has been developed in certain countries where they adopted an approach by community. For example, in the United States, in Australia, in France, it's not the case at all. There isn't really a spirit of community as such, and policy is against this community approach. They prefer integration. But due to this grey area, other branches developed. So we see interpretation, for example, in the medical field, we see there was a need to have a greater knowledge and more significant training where it concerns medical aspects. Now, there really is a speciality which is being created, and I have the impression that community interpreting in the social arena is going to finish by having lots of different branches which are going to develop further. But if we look at the worst aspect for us now, for our reputation, which could make our image suffer, is the situation with emergency interpreting. This is since the refugee crisis. Solutions had to be found, immediate solutions, and it wasn't possible to have sufficient interpreters in all these new languages and get them quickly available. There wasn't always cooperation between the interpreters, the professional associations of interpreters, and the authorities dealing with refugees. So the situation that arose was that these administrations responsible for refugees sometimes were so naive as to contact the consulate or the ambassador or the embassy of the country, and there were, in totalitarian regions, for example, they contacted interpreters who were recruited by the consulate. Now, these pseudo-interpreters denounced the person who was asking for asylum in the country, and the families were killed, assassinated. So, due to a lack of information and cooperation with the people responsible for interpretation, with trainers, we have seen tragedies occur. Up to 2 years ago, I found that this situation was catastrophic, but nevertheless, it was essential to have interpreters who were trained at the highest level for this, and I was asked to participate in such initiation trainings, and I saw that the situation that was most practical was to have progressive module training and to really limit the task of that person who was responsible for interpreting for refugees, stressing ethics and training the recruiters to choose who they recruit properly, such that such events do not occur in the future. And now I would go for a modular training, go up to the highest level, but starting with a preliminary level. And this was something that was done for years in the University of Zurich. They started with different modules which became increasingly complex in order to come to a very good level for the training of legal interpreters. And what I find shocking is that there was a movement among academics. They thought it was a good idea to launch conferences under the title of non-professional interpreters and translators. So this idea, well, the idea wasn't bad, the subject. This was to see how to manage the situation when people who are unqualified have to speak. But if we see where it is now, anyone could therefore improvise and say that they're an interpreter, with the idea that interpretation can be practiced spontaneously, and that damages us and our reputation. I have tried very hard to ask the colleagues who launched this to stop. I found that it was wrong, and it was very harmful to the interpreters who were called upon, but it's harmful to our reputation as well. Once an interpreter is not working correctly in any domain, make no mistake about this, people think interpreters are rubbish, and we are concerned as well. So you have to be aware of the fact that interpretation, or anything that is interpretation, all fields in interpretation concern us. And every time that somebody makes a mistake or error, whatever domain that comes in, that affects us all. We cannot remain in a bubble. Now, with regards to this training, you have to be creative and you have to be didactic. Everybody has to be trained, in particular in ethics. Now, if we look at the conclusions and perspectives, legal interpreting is practiced at national level, and it is just as complex as conference interpreting. Furthermore, you know that as a conference interpreter, we work for international courts, and very often at the European Court of Justice or at the European Court of Human Rights in Strasbourg, you have cases which have started in a member state. There was the assistance of interpreters who were more or less qualified, and at the end, that goes to an international court. The content's the same. The questions are the same. So why would you accept two-speed interpreting? And here I would like to cite a colleague, Holly Mickelson, who's done a lot for the profession. She said, interpreting is interpreting. Or is it? And I think this really does sum up the approach, and our approach in our committee. So, of course, certain courts recognize that it's important to have qualified interpreters. However, even having well understood that, these courts do not see why they have to be paid in such a way that they can live from that. And the misunderstanding, or the point that's never been expressly said, while AIIC wasn't in favor of supporting legal and court interpreting, was precisely on the issue of remuneration and the fact that interpreters who can work correctly are badly paid. That can also impact on us and create competition. So the market, I don't have to tell you about that. If you speak to young interpreters who are starting on the market, the interpretation market is shrinking. And in terms of quality, in terms of the interest that there is, legal and court interpreting is extremely gratifying, it's extremely interesting, but only qualified interpreters who know what they're talking about will be able to improve this market, to improve the quality and the working conditions. What's the problem? Why are there so many abuses? Why are there so many deplorable situations with regard to this market, this legal interpreting market? Because of the number of people who are practicing in it who are not qualified. Because there is not much training available, and these people are afraid of being trained. They don't want to lose the money and the little money that there is in the market. They would rather have certainty. And they don't, for example, a judge, for example, they don't want to take such training. So what our profession did, what we found at Nuremberg, was we really came to the fore. Our profession came to the fore then. Legal interpreting, which is carried out in national courts, comes directly from the Nuremberg trials and the practices in Nuremberg. So why should this tradition not be imposed once again on national courts? I think that we can reach that if we all work towards that. Thank you very much for your attention.